You appear before the trial court. Heard Mr. K. Thakur.
B. Methi Lordship.
Heard Mr. B. Methi, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has already been laid in this case. You have the reference
Yes, number.
Dating.
CS number 401/23
bearing
dated
CS
31/10/23.
in view of the laying of the charge sheet, this anticipatory bail application has become infructuous and accordingly disposed of.
Lordship, direction may be
The petitioner may approach the learned trial court and may pray for regular bail there if so advised.
obliged, Lordship.
Trial court lordship directed to produce the relevant documents before the IO. Accordingly, I went there and on my appearance, I was taken into custody. And my case is that lordship, that driver and handyman were apprehended on the date of the, when FIR was lost. Immediately they were arrested. Neither they implicated me, nor there is any material to connect me with the alleged contraband lordship. This is my case.
Okay.
In nutshell, lordship, I have submitted. Other day also your lordship has seen, and even if your lordship see the charge sheet, in the first charge sheet, they only said that they will say, just I'm taking 2 minutes time of your lordship. Page 31, lordship, only there. Page 31. In whole letter, they said they issued notice to me. And in after those bold, your lordship will find that they stated that accused Sujan Mia and the other against other accused Amdadul Haq, against them materials are there. And last paragraph, lordship. However, lordship, got it?
Yes.
However, this charge sheet may be treated as part in nature and a supplementary charge sheet along with the SCD shall be submitted to the Honorable Court once the statement of actual owner has been recorded. So, in terms of that notice, I appeared and I was taken into custody. After my arrest, they filed supplementary charge
When
sheet.
were you taken into custody?
I was taken into custody on 5/4/2023.
Since then you are behind the bar.
Lordship, 296 days, as on, 300 days, lordship, as on today. And supplementary charge sheet, your lordship will find page 38.
Yes.
After those bold, your lordship will find on 5/4/2023, the owner of the vehicle, namely Abul Kasem, came to the PS, recorded his statement, and he was found suspected to be accused person in connection with the above reference case, so arrested him and has been forwarded to the judicial custody. On the basis of the FSL report, on the other day also I submitted FSL report, I am not disputing. MBI report, I am not disputing because I am claiming that I am the owner of the vehicle. Vehicle reported from Bahan Samawai, Karimganj, Assam. The prima facie is well established that the MBI report that the arrested person, namely Abul Kasem, is fully involved in the activities of trafficking and smuggling illegal narcotic drugs from the Tripura. So this is their case. I am not disputing the FSL report. I am not disputing that I am not the owner of the vehicle. But apart from that, there is no material to suggest that I am involved in that business.
Then why your vehicle has been used?
My vehicle was it is my commercial vehicle. The driver informed me that the vehicle was the truck, lordship. It is a truck. They said that truck is going to be deliver poultry food in Meghalaya. Accordingly, I allowed, lordship. What they have carried, your lordship will not find the statement of the driver and handyman, even not in my statement that I have allowed to carry the contraband. Only material which, in my understanding, subject to what my learned senior
Under
friend said,
what provision charges were framed?
Charges were framed 25 and 29,
25 is allowing the vehicle to be used.
Lordship.
So
There has to be proof that I have, with knowledge I have allowed.
Okay.
That knowledge
where
is,
is, let us read 25.
Lordship. Section 25. Lordship got it?
Yes.
Punishment for allowing premises, etc. to be used for commission of an offense. Whoever being the owner or occupier or having the control or use of any house, room, enclosure, space, place, animal, or conveyance, here my vehicle will come, conveyance, knowingly permits it to be used for the commission by any other person of an offense punishable under any provision of the act shall be punished with the punishment provided for that offense.
Okay. And what is 29? Here
So
your
just-
plea is
just-
that you didn't have the knowledge.
Knowledge. And here in that part, your lordship will find after conveyance, knowingly permits to be used. The word used here is knowingly permits.
And
And
29,
29, your lordship will punishment for abatement and criminal conspiracy.
why this cannot be?
Because there has to be some discussion that I have or knowledge that I know that my driver is carrying, or I allowed him to carry those contraband. Then only abatement or conspiracy will come. From the statement of the driver, handyman, and the present appellant, your lordship will not find that there is any knowledge that contraband was carried.
Okay. Anything else?
That much. And even in the supplementary charge sheet, lordship, page 39, your lordship will find. Page 30.
Then why at the time of framing charges, you have not raised this?
We have raised, but the charges are framed.
But you have not challenged.
No, we have not said.
This bail application is filed before the framing of charges or after?
This bail application was filed, this was filed subsequently.
Okay.
Earlier one was filed prior to framing of charge, which was decided subsequently after framing of charge. So at the time of filing that bail application, charges were not framed and documents were not.
Earlier bail application.
Yes, but
Then why that was rejected?
that reasoning was subject to correction. Page 40, your lordship will find. And 11% your lordship will find page 42. Probably it was an at early stage of 60 days. Probably. It appears, page 42, first line your lordship will find. It appears that accused petitioner has been in judicial custody since 6/4/2000, that is for 60 days. A perusal of the case record, it is revealed that the learned trial court has framed charges under section so-and-so by order dated so-and-so, and thereafter none of the prosecution witness numbering 10 is
Charges
examined.
under, not only under
29.
29, but also under 25.
Yes,
The charge sheet
Yes,
was
sir.
laid
Sir.
under
25,
29,
29 charge sheet is there. That's
but
fine.
in the order sheet, 25 is missing.
If it is
Charge
not
framing
framed, then
order
it is a
was-
good case for
That's
me.
framing order to Asanagi.
Yes, I'm checking. In the record, it is there. I can check it. Only on the, because lordship, the present case has been implicated, middle portion your lordship will find. Present accused has been implicated in the case on the basis of statutory provision under section 29 of NDPS Act. In view of the above reasons, bail
yes,
application
yes.
stands rejected.
That is there, that is,
Only there.
yes.
If the frame one, so charge to.
Okay. Anything else?
This is my whole submission bill. Except lordship that I am the owner, nothing is there. Even the
But
person
once charges are framed
to lordship,
in a bail application,
yes.
can the court consider that whether reasonable grounds are there
Yes.
as to whether he has
can be.
committed, because
Absolutely.
once this view has already been taken while
Right.
framing charges against you.
Lordship. There is a Supreme Court judgment which says, Lordship, for consideration of bail, that FIR and framing of charge need not be challenged. That judgment I will place after some time, actually, Lordship. I'll
That I-
place to him.
That
I have that copy, but I have not printed out. So as your Lordship has pointed,
you
very-
tell me the citation.
Lordship. Just, so I'm taking my seat, Lordship.
Oh, yes, yes. Yes, Mr. Gogoi.
Yes, Lordship, our case is that, my lord, this is contravenes is, my lord, commercial quantity. It was recovered from his vehicle.
But suppose your vehicle has been used by two persons
Yes.
whom you have not authorized to carry.
No, here, my lord, he is regular driver, my lord.
But regular driver has not made any statement that it was authorized by they have been authorized to carry poultry goods.
Poultry goods.
Suppose driver carries contraband, prohibited drugs without your permission, without your knowledge in your vehicle, can you be implicated?
No, that is, my lord, depend upon facts and circumstances
No,
of
what
the
are the
case, my
facts
lord.
in this
Facts
case?
and circumstances. The
That is my question.
Evidence will, witnesses will prove the case, my lord.
No, at this stage, for consideration of bail application, what are the materials? Because they are saying that at this stage, there is no material at all, except the fact that he is the owner of the driver,
Yes, yes,
owner of the vehicle,
yes. Owner of the vehicle, my lord, that is,
and no implication.
that section 25 and 29, my lord, that will come, my lord. Yes.
Charges. Charge is framed only for possession.
That is.
If you read the charge, it is
Then
not
that is-
mentioned in the charge, apart from mentioning of the sections that your vehicle was knowingly allowed to be used.
Yes.
That narration has to be there in the charges, memorandum of charges. It is not there. It is only mentioned that you were found to be in possession. But the present petitioner was not found in possession. Charges against him ought to have been different.
Lordship.
Even if there are certain materials, charges ought to have been that you have abetted,
Lordship.
you have conspired with so and so,
Um,
and you have allowed your vehicle to be used, knowingly used. No such framing of charges.
Only evidence will prove, my lord, on that is, my lord, in cross or like that, my lord, at 313, then only it will come.
You found that judgment?
Yes, Lordship. I have mailed it. It is Tista Atul Sitalwad. That Gujarat case, Lordship. Probably.
Citation?
It is not reported, Lordship. It is recent on criminal appeal number. I shall mail to. Please be on. Just one line I am reading, Lordship. In paragraph 28, it is observed that If the observations as recorded by the learned judge are to be accepted, then no application for bail at a pre-trial stage could be entertained unless the accused files an application for quashing the proceeding under section 482 CRPC or under Article 226 or 32 Constitution of India.
Okay.
So after discussing it, paragraph 25 onwards, Lordship will find.
So ultimately, what has been said?
Ultimately, bail granted, and it is said that it is not necessary to file
Where?
exact paragraph I am reading.
Last of
Lordship. From 25, Lordship, may I read from 25, Lordship? The learned judge has further observed that since the appellant, after filing of an FIR and filing of a charge sheet, has neither challenged the same in a proceeding under section 482 of the Code of Criminal Procedure or under Article 226 of the Constitution of India before the High Court or under Article 32 of the Constitution of India before this court, it is not permissible for her to contend that a prima facie case is not made out. In the limited understanding of law that we have, the factors which are required to be taken into consideration at the stage of grant of bail are prima facie case, number 2, the possibility of the accused tampering with the evidence or influencing the witnesses, number 3, and possibility of the
To
accused
say
being
the least, the findings are totally perverse.
Lordship.
29, para 29.
Yes. Yes, 28 and 29. That.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B.V. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abul Qasim, who has been detained behind the bars since
5/4/2023.
since 5/4/2023, within bracket for last 300 days in connection with Bajari Sera PS case number 196/2022, corresponding to special NDPS case number 160/2022, pending in the Court of Learned Special Judge Karimganj under section 20 within bracket small b within bracket small Roman 2 within bracket capital C /25/29 of the NDPS Act, 1985. Stop. The gist of acquisition in this case is that on 11/11/2022, one Shri Niranjan Das had lodged an FIR before the officer in charge of Bajari Sera Police Station, inter alia, alleging that while conducting a daily routine Naka checking duty at Naka checkpoint of Suraibari watch post at National Highway number 8, one six-wheeler goods carrier truck bearing registration number TR01B 1747 was intercepted, and during search of the said truck, $69 packets containing suspected ganja within bracket cannabis was recovered. The total weight of the recovered ganja was 404 kgs. The driver and the helper of the said truck, namely Sujan Mia and Amdadul Haq, were apprehended as they could not give any satisfactory explanation regarding the recovered contraband. On receipt of the said FIR, Bajari Sera PS case number 190. How much? PS Bajari 196/2022 under section 20B2C/25/29 of the NDPS Act was registered and investigation was initiated. It is stop. Stop. On when the first charge sheet was laid,
First charge sheet was laid on 28/2/2023, page 21, your lordship will find.
on 28/2/2023, a part charge sheet was laid against the apprehended accused persons, namely Sujan Mia and Amdadul Haq under section 20B2C/25/29 of the NDPS Act. And thereafter, on 13
Next.
on which date?
Supplementary charge sheet on page 36, 13.
Thereafter, on 13/5/2023, a supplementary charge sheet was laid against the present petitioner under section 25/29 of the NDPS Act. Stop. Mr. A. Ahmed Learned, Learned Counsel for the petitioner has submitted that though the Court of Learned Sessions Judge, Learned Special Judge Karimganj has framed charges under section 20B2C/29/25 of the NDPS Act against the present petitioner also, along with the other two charge sheeted accused persons. However, there is no materials on record to implicate the present petitioner under any of the provisions under which the charges were framed against him. It is submitted by Learned Counsel for the petitioner that the present petitioner is the owner of the seized truck, and his truck was used by his driver and helper to transport poultry goods to Meghalaya, and he was not knowing that the said truck has been used for carrying prohibited contraband. It is also submitted by Learned Counsel for the petitioner that the custody of said truck was given to the
No,
petitioner.
not given, lordship. He filed JIPMA application, and in the JIPMA application, trial court directed me to produce all the relevant documents before the
Okay.
IO.
He filed a JIMA application before the Learned, which court?
Session Judge Karimganj.
Learned Sessions Judge Karimganj, who had directed the present petitioner to appear before the investigating officer for producing all the relevant documents before the investigating officer. And on 5/4/2023, when the present petitioner went to the investigating officer along with the documents, he was arrested in connection with this case, and a supplementary charge sheet was laid against him. It is further submitted by learned counsel for the petitioner that neither the driver nor the helper of the seized truck have made any implications or any incriminating material against the present, incriminating statement against the present petitioner. It is also submitted by learned counsel for the petitioner that in the supplementary charge sheet which has been laid against the present petitioner, it is not clarified as to what incriminating materials are available on the basis of which charge sheet has been laid, as it has only mentioned about the MVI report as well as FSL report, which in no way implicate the present petitioner in the present case. Learned counsel for the petitioner has also submitted that to implicate the present petitioner under section 25 of the NDPS Act, it was incumbent upon the prosecution to show that the seized vehicle of which the present petitioner is the owner was used for carrying prohibited contraband with the knowledge of the present petitioner. However, there is nothing on record to show that the petitioner knew that his vehicle was used for carrying prohibited contraband. Similarly, learned counsel for the petitioner has also submitted that there is nothing apart from the fact that the petitioner is the owner of the seized vehicle. There is nothing on record to show that there was any abatement or any criminal conspiracy of the present petitioner with the other two co-accused so as to implicate him in this case. Hence, it is submitted that there is no materials on record to implicate the present petitioner under the provisions under which the charges are framed, and therefore there is reasonable ground to believe that he is not guilty of the offense against which offense under section 20B2C/29/25 of the Indian Penal of the NDPS Act. It is also submitted that in view of above, the embargo of section 37 is not applicable in this case. Learned counsel for the petitioner has also cited a ruling of the apex court in Tista Atul Sitalwad within inverted comma versus State of Gujarat, comma within bracket, order dated order dated 19 July 19/7/2023 in SLP within bracket criminal number 8503/2023, wherein the apex court has made an observation that merely because charges here FIR and charge sheet was not challenged.
Not challenged.
That you are drawing an analogy that what was the last line? Merely because after filing of the FIR and after filing of the charge sheet, the appellant neither challenged the same in a proceeding under section 482 of the Code of Criminal Procedure or under Article 226/32 of the Constitution of India to hold that it is not permissible for the appellant to contend that there is a prima facie case is not made out would be a perverse finding. Learned additional public prosecutor has, learned counsel for the petitioner has also submitted that in the instant case also, merely because of the fact that the trial court has framed charges even in the absence of any materials on record, and merely because the said charges are not challenged in an appropriate, said framing of charges are not challenged in an appropriate proceeding, he is not precluded from taking a plea that no case has been made out in a bail application. Stop. On the other hand, Mr. B.B. Gogoi, learned additional public prosecutor, has submitted that since the vehicle in which the contraband was recovered belongs to the present petitioner, and since the quantity of contraband seized is of commercial quantity, the embargo of section 37 would be applicable in this case, and he opposes the grant of bail to the present petitioner. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the scanned copy of the case record of special NDPS case number 160/2022, which was requisitioned from the Court of Learned Special Judge Karimganj. In the instant case, it appears that though on 9th day of June 2023, charges were framed against 3 numbers of accused persons, including the present petitioner under section 20B2C/25/29 of the NDPS Act. However, on perusal of this perusal of the memorandum of copy of the memorandum of charge, it appears that the only accusation made against the present petitioner was that he was found in possession of 69 packets of suspected ganja within bracket cannabis weighing about 404 kgs. There is no mention in the said charge regarding allowing the seized vehicle to be used by the other co-accused knowingly by the petitioner, or anything regarding any accusation regarding criminal conspiracy or abetment to commit the offense. Offense punishable under chapter 4 of the NDPS Act, 1985 by the present petitioner. It also appears that when the seizure of the seized contraband was made in this case, the present petitioner was not in the seized vehicle, and only other two petitioners were found. Other two accused persons were found. Seizure was made. Therefore, the petitioner cannot be said to be in conscious possession of the seized vehicle. Regarding charge under section 25 of the NDPS Act, in addition to absence of any narration in the charge memorandum of charge regarding any offense under section 25 of the NDPS Act, there is no material on record to show that the vehicle bearing registration number
Vehicle bearing registration number.
ER01B1747 was knowingly permitted to be used by the present petitioner, by the other two accused person for commission of an offense punishable under NDPS Act. Hence, prima facie, it appears that there is no material against the present petitioner under section 25 of the NDPS Act. Similarly, in addition to absence of any narration in the memorandum of charge against the present petitioner under section 29 of the NDPS Act, there is no materials on record to suggest that the present petitioner has conspired, present petitioner has entered into criminal conspiracy or has abetted commission of an offense punishable under chapter 6 of the NDPS Act with anyone, as none of the witnesses or even the co-accused persons have implicated him for commission of the said charges, said offense. Stop. In view of above, this court, for the limited purpose of consideration of the instant bail application, is of the opinion that there are reasonable grounds for believing that the present petitioner is not guilty of the offense against his offense for which charges are framed against him. Stop. Further, there is also no material of any previous criminal antecedent on record, and therefore there is no material to suggest that he would commit that there is no materials on record to suggest that he is likely to commit any offense if he is released on bail. Therefore, this court is of considered opinion that the embargo of section 37 of the NDPS Act is not applicable in the instant case. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Karimganj, with following conditions: that he shall cooperate in the trial of NDPS case number 160, special NDPS case number 160/22, pending before the Court of Learned Special Judge Karimganj. Number 2, that he shall not either directly or indirectly make any inducement, threat, or promise to any person who is acquainted with the facts of this case so as to dissuade such person from deposing against him in the pending trial of special NDPS case number 160/2022. Number 3, that the above named petitioner shall not leave the jurisdiction of the learned Special Judge Karimganj without prior leave during the pendency of the trial, without prior leave of the learned Special Judge Karimganj. Stop.
Lordship, he belongs to Tripura, my lord. So two local sureties,
From where he belongs?
my lord, resident of Tripura.
I have no objection to say.
You can arrange local series.
One local surety.
Okay.
One local surety.
Instead of
One.
in front of, before the word surety, add local. Surety who has his residence in the state of Assam. So it is hereby made clear that observations made here shall be limited, is only for the purpose of considering the instant bail application, and the trial court it shall not in any manner and the trial court shall not be in any manner shall not in any manner be influenced by the observations made herein before regarding the line to correct. I will make corrections in this. With above observation, this bail application is hereby disposed of.
Obliged.